พร้อมหรือยังคะเดี๋ยวนะพร้อมแล้วมานั่งประจำที่ได้เลยนะเดี๋ยวเราจะเริ่มไลฟ์แล้วค่ะให้เช็คเสียงนะคะได้ยินปะ
ท่านอาจารย์ปกิตาพร้อมนะฮะท่านอาจารย์รัชการพร้อมนะงั้นพี่มะเฟืองเริ่ม
Good afternoon, ladies and gentlemen. Welcome everyone to the ASEAN Law Association of Thailand Moot Competition 2026 final round. And also welcome everyone who's watching the live streaming via Facebook Live and YouTube. My name is Sanaporn Gawatana. I'm a legal officer, practitioner level of the Thai Arbitration Institute Office of the Judiciary or the TAI, and I will be your MC for this event. The ASEAN Law Association, or ALA, is an international organization of legal professionals from ASEAN member states, established in 1979 with the objective of promoting cooperation, mutual understanding, and professional relationships among legal practitioners in the ASEAN region, as well as supporting the development and exchange of legal knowledge among member countries. The ASEAN Law Association convenes its General Assembly every 3 years as a forum for legal professionals in the region to discuss and exchange views on legal developments and issues of common interest. For the year 2026, Thailand will host the 15th ASEAN Law Association General Assembly and the 47th ASEAN Law Association Governing Council meeting, scheduled to take place from 19 to 24th July 2026 in Bangkok, Thailand. As part of these events, the ASEAN Law Association Moot Competition 2026 will be organized to promote legal education and develop the advocacy and analytical skills of law students across the ASEAN region. This competition will be the second edition following the inaugural competition previously held in Malaysia. The ASEAN level rounds are scheduled to take place on 21st to 22nd July 2026. In this regard, the National Committee of the ASEAN Law Association of Thailand, with the Office of the Judiciary serving as the Secretariat, organized an ASEAN Law Association of Thailand Moot Competition 2026 on 17 to 18 March to search for the team representing Thailand at the ASEAN level competition. The competition aims to provide students with the opportunity to apply their legal knowledge in a practical setting, enhance their legal research, analytical and advocacy skills, and promote academic cooperation and legal engagement among ASEAN countries. Before we start the competition, I would like to inform everyone who's watching the live streaming about the rules. Only 2 mooters from each team will be allowed to submit their oral submission to the panel of judges, and the additional team members may sit next to their team's representatives. Each team is allowed 45 minutes for the oral submission. The first and second mooters from the Claimant's team are allowed to perform in the oral session for 20 minutes each. Then it will be the first and second mooters from the Respondent's side, which also has 20 minutes for each mooter. After that, a 5-minute time period will be given for rebuttal and sur-rebuttal for each part. The time will start when the first mooter begins the oral session. Alarms will sound when there are 5 minutes left, 1 minute left, and will sound again when the time's up for each oral session, except for the rebuttal and sur-rebuttal, in which the alarm will sound when there is 30 seconds left and when the time's up. Today's final round competition is between Team A and Team E, and we have 3 honorable judges with us today. The first judge, may I introduce you to Professor Vichai Aryanantaka, the advisor to the TAI. Secondly, Judge Pakita Nipawan Chodkitikun, Judge of the Office of the President of the Supreme Court. And thirdly, Mr. Rattakan Bunnea, partner at Watson Farley and Williams. Ladies and gentlemen, now it is the perfect time to start our final competition. We will start with the oral submission from the first mooter of the Claimant's team. Thank you.
Thank you, Kun Mafeng of the Thai Arbitration Institute. This is the 2026 Moot Arbitration Moot, organized jointly by the Office of the Judiciary, Thai Arbitration Institute, and the Thailand chapter of ASEAN Law Association, chaired by the Honorable Chief Justice, the President of the Supreme Court of Thailand. Today, we will be hearing the closing statements from two very good mooters from two greatest universities, law schools in Thailand. And this is in the matter of an arbitration at the International Center for Settlement of Investment Dispute, Washington, D.C. And the dispute concerning the agreement establishing an free trade agreement between the Claimant, which is a corporation incorporated under the law of the Republic of Andorra, Londonist Green Co. Incorporated, and the respondent will be the Kingdom of Mustafa. Both teams will be represented by two counsels. Each counsel will have 20 minutes for presentation to convince us that you're right. And then we have 5 minutes for rebuttal and sur-rebuttal. So if all the counsels are ready, we may proceed with the first counsel for the Claimant.
Thank you.
And meanwhile, the tribunal may interrupt if and when it thinks appropriate in order to extract from you the essence and the point that will give the best light of your argument, not necessarily to test your ability to respond, but in order to make clarification on the point that you are making. You may proceed.
Good afternoon, Mr. President, members of the tribunal. My name is Kandapat Haratgetgun, and I rise along with my co-counsel, Ms. Atipathiran Bandit. We are appearing here before this tribunal on behalf of Londonist Green Co. Incorporated, the claimant in these proceedings. There are three issues presented before this tribunal. I will submit the first issue, which is the jurisdiction and the court's admissibility of the claims. And my co-counsel will submit the merits issue, which are the breach of FET and the expropriation. I will speak for 20 minutes and likewise for my co-counsel, and we respectfully reserve 5 minutes for rebuttal. Accordingly, my submission is divided into three main parts, First, the tribunal poses jurisdiction rationale voluntatis as all procedural prerequisites are met. Second, the tribunal poses jurisdiction rationale materiae as the disputed investment is under protection of the NFTA and the corruption allegation does not discard such protection. ครับผม
The problem with the timing. You may proceed. We can also, not the digital timing, but the mechanical timing. So you may proceed without the defect of the digital timing. Go on.
Okay, thank you. And lastly, and the third point, the claims are admissible as they are not precluded neither by the principle of res judicata nor the principle of collateral estoppel. With the tribunal's permission, I shall turn to my first submission. Members of the tribunal, the claimant turns now to jurisdiction rationale voluntatis as the claimant has fulfilled the cooling off period requirement. Jurisdiction rationale voluntatis refers to the parties' consent to the arbitration, which is expressed through the arbitration clause in the treaty. In other words, the questions here are whether the claimant has satisfied the arbitration clause and whether the failure to satisfy the clause defeat the jurisdiction of this tribunal. The claimant submits that, first, is strictly observe the period, and alternatively, the period is merely procedural step which does not defeat jurisdiction. May I turn the tribunal's attention to page 20 of the moot, to the page 18 of the moot problem, please. If the tribunal examines Article 20 closely, it requires only the investor to provide information regarding the legal and factual basis for the dispute, nothing more. The claimant's letter on the 4th April 2025 clearly identified the investment, the regulatory change, and the harm caused. The respondent's demand for detailed legal analysis exceeds what Article 20 requires. This tribunal, it is to be noted that the purpose of consultation under Article 20 is amicable settlement, which by definition is a cooperative dialogue to understand each other's concerns and explore solutions together, not a legal combat. Thus, legal grounds need not be thoroughly discussed at this stage. Since the dispute remained unresolved for 180 days later, the claimant was entitled to submit its request for arbitration on the 1st October 2025, pursuant to Article 21 of the NFTA. The cooling-off period was thus observed strictly. Second, even if there were procedural irregularities, the cooling-off period in the NFTA is merely directory, not mandatory jurisdictional bars, meaning that the failure to comply with the period does not defeat jurisdiction of the tribunal. In Bywater Gulf versus Tanzania, the tribunals held that non-compliance with directory provisions does not defeat jurisdiction. And the reason the claimant is citing that case is because the BIT between the UK and Tanzania in Bywater case and the NFTA between the respondent and the claimant in this case hold several similarities, in that they share the same purpose, which is amicable settlement as have previously established, and comparable mandatory language. Notably, Article 20 of the NFTA uses the softer wording, which is shall as far as possible, while the Bywater's BIT used a stricter wording, which is shall. If the stricter language in the Bywater case did not create a jurisdictional bar, Article 20 of the NFTA, which uses the softer word, cannot impose one either. Therefore, the tribunal's jurisdiction rationale voluntatis stands, whether the 180-day cooling-off period was strictly observed or not. Honorable members, may I proceed to my next submission on the regime materiae. The claimant insists that regime materiae is clearly established, as the claimant would like to turn the tribunal's attention to page 14 of the moot problem to examine Article 1C of the NFTA closely. Such article encompasses every kind of asset. In this case, Londonese holds 100% of the shares in Gogura Green Energy Incorporated and possesses rights under the 30-year power purchase agreement with Mustafa Electric Secret Limited, which are listed in Article 1C as a covered investment under the sacred protection of the NFTA. As a result, jurisdiction regime materiae is clearly established under the NFTA. Your Excellencies, the claimant further submits that the respondent's corruption objection does not defeat jurisdiction regime materiae on three distinct grounds. First, the respondent fails to prove that the claimant has involved in any corruption acts. Second, even if the claimant had involved, the respondent is stopped from raising the corruption allegations. And third, objections on corruption does not bar the tribunal's jurisdiction due to the lack of legality clause. First, the claimant denies any involvement in corruption. The claimant submits that the transactions identified as suspicious are consistent with legitimate business conduct. For example, the consultancy fee was made pursuant to a signed contract for strategic investment advice in a new market, and the watch was given only as a standard corporate hospitality and cultural protocol. Under the EDF versus Romania and SIAC versus Egypt case, corruption allegation carry severe penal consequences and require clear and convincing standard of proof. And the burden of proof of corruption lies on the respondent under Rule 36 of the ICIT arbitration rule, which states that the party that rely on such a fact to make a establishment of their defense or their claim must satisfy that burden of proof. Here in this case, the claimant submits that the respondent has not discharged that burden. It relies solely on special committee prima facie finding, which is an investigation conducted by PM Wanachai's long-standing political rival, and not a single criminal conviction, and not a single criminal conviction against Londonese itself. Even the Mustafa prosecutors themselves acknowledged in Exhibit R4 that they were not yet able to prove that there was no legitimate legal business justification for the payments. The claimant further submits that the transactions identified as suspicious do not satisfy the legal definition of corruption. Under Article 15 and 16 of the UN Convention Against Corruption, bribery requires a payment made to a public official in exchange for a specific official act. In this case, the alleged payments were made to PM Wanachai's son, and the watch was given to his wife. Neither
Also,
of them.
you raised the standard of proof of clear and convincing. This is a civil case. What are the standard of proof in a civil case against a criminal case, and where clear and convincing lies?
Thank you, Mr. President. We have noted your concern, and the claimant would like to clarify that normally in the civil case, the standard of proof would be preponderance, which is only more than 50% of the possibility would establish some facts into the tribunal. On the other hand, in the court of criminal law, the standard of proof would be beyond reasonable doubt. But in this case, as established in EDF versus Romania and SIAC versus Egypt, which are also the investment case as in this case, they have established the standard of proof of clear and convincing, which is in between the proof beyond reasonable doubt and the preponderance.
This is very much a jurisprudence on the law of evidence.
Yes.
Can you cite any authority besides from an award that when even in a criminal case, in a civil case, when the allegation is as serious as fraud or corruption, then you need a higher standard of proof of maybe not yet beyond a reasonable doubt, but higher than preponderance of evidence or balance of probabilities.
Yes, exactly. In this case, the EDF versus Romania explicitly stated in their rulings that corruption allegations and fraud carry severe penal consequences and thus require the utmost care and sense of responsibility to prove beyond the standard, which is the clear and convincing standard.
That's an award, wasn't it?
It is, exactly.
Do you have any customary law or practice in the courts on this, or the law of evidence on this, besides this award?
Besides the international award rulings?
Well, then normally arbitral awards, the rule of law derived from international recognized the law, including the law of evidence. All right.
The claimant would like to submit that the rulings of these courts, of these tribunals that we have submitted, are already the CIL. Yes.
Okay. And then you are convinced that the evidence or the facts established in this case does not qualify as clear and convincing.
Yes.
All right, go on.
Thank you. May I proceed? In this case, the alleged payment. Furthermore, the respondent failed to identify which specific governmental acts were obtained in direct exchange for a specific payment. It is pointed plainly at the payments. Thus, the facts of corruption is not established. According to the text of Article 15 of the UN Convention Against Corruption and the EDF versus Romania, what remains is only merely suspicion. And as confirmed in Ampao versus Egypt, allegations based entirely on suspicion cannot discharge the burden of proof. The corruption objection, therefore, must fail. Secondly, even if the claimant had involved in corruption, the alleged acts of corruption were closely tied to Mustafa's own state organs. in that the gifts and consultancy fees involved the Ministry of Energy and the Coal Business Authority under Article 4 of the Articles on Responsibility of State for Internationally Wrongful Acts, or ASAIWA as I will say it further. The knowledge of these officials is the knowledge of the state itself. Having known that, the respondent chose to overlook any suspicious actions in order to reap the benefits of the plant for 12 years, when it has several opportunities to exercise due diligence through annual tax audits, official reviews, and the 2017 PPA renegotiation. Therefore, the state of Mustafar knew, or at least should have known, about the illegal conducts and is now stopped from raising these allegations as a defense for jurisdiction, as firmly appealed in the case of Freeport versus Philippines the First and Desert Line versus Yemen. Third, the objection on corruption does not bar the tribunal's jurisdiction, as the NFTA contains no legality clause. The respondent raised corruption to deprive this tribunal of her jurisdiction, claiming that the claimant had not come to the tribunal with clean hands. It is important to establish that the clean hands doctrine is an equitable principle, providing that a party who has engaged in illegal conduct to his own claim cannot seek relief from a tribunal. The claimant plainly rejects this defense, as in Yukos Universal Limited versus Russian Federation, the tribunal concluded that the so-called clean hands doctrine does not bar the jurisdiction in absence of a legality clause. Members of the tribunal, a legality clause is an express treaty provision requiring that an investment be made in compliance with the host state's domestic law as a condition for treaty protection. In this case, the governing law, which is the NFTA, does not contain such a legality clause. May I turn the tribunal attention to the page 14, please. In Article 1A of the NFTA, the phrase "subject to its relevant law" is simply an acknowledgement that the investment exists within the legal framework of the host state, according to its ordinary meaning from Oxford Dictionary. The provision only indicates that the investor must obey local laws during its operation. It does not require perfect conformity with every rule of law as in a legal clause, as in a legality clause. If the drafters intended for any domestic legal violation to disqualify an investment from protection, they would have used the specific restrictive language found in treaties like the phrase "in accordance with law," seen in Incesa versus El Salvador and many other cases. The phrase carries entirely different legal charge. The Oxford Dictionary defines "in accordance with" as signifying an affirmative command of exact conformity. The NFTA drafters chose different language here. Under the canon of deliberate drafting, that choice is intentional. Thus, the subject to phrase imposes merely a boundary acknowledgement, not a jurisdictional compliance test. Therefore, it is not a legality clause. Furthermore, actually to the page 60 of the Moot problem. The respondent has claimed that the claimant has breached their anti-corruption law, yet it has not been able to provide any clause of anti-corruption law the claimant has breached. As in page 60, Exhibit R1, it provides only Section 7 of the Anti-Criminal Code, which convicts the person accepting the bribe, never the person giving the bribe. Therefore, the facts that the respondent tell that the claimant has breached their domestic law has not been established, as they fail to provide any of the laws accused to be breached.
Interesting, you say that, receiving is an offense, but giving is not.
Yes.
But as a matter of public policy, you mentioned legality.
Yes.
Does the word legality incorporate honesty, incorporate good faith? How could you involve in a heinous behavior as a giving of bribery be exempted from or exonerated or immune from being corrupted and against public policy.
Yes, thank you. Public policy in this case, I believe at the very end of the Article 1A has subjected its relevant laws, regulations, and policies. And that is what you are citing. Is it correct, Mr. President? The policy in this case is only the domestic policy, not international policy.
Can you cite a domestic public policy, one country in the world, one jurisdiction in the world that fraud is not against local public policy?
I cannot, but in this case, as I have established before, the respondent has the burden of proof under Article 36 of the Rule on Arbitration. Therefore, they have to provide the facts that they have such policy in order to accuse us of breaching such policy.
All right, so you deny that this is not against public policy.
Yes, unless they can provide it. Because the burden of proof lies with them.
Right. Go on.
Thank you. And moving on to my last submission on admissibility. Honorable members of the tribunal, I turn finally to the admissibility of the claims. The respondent have raised res judicata objection based on the prior Hawk Capital versus Mustafa award. Res judicata is a principle that prevents a party from relitigating a dispute that has already been decided by a competent tribunal. International law requires the triple identity test in order for the res judicata to apply. They are identity of parties, identity of object, and identity of legal grounds. Here, it is to be discussed whether the identity of parties fails or not. In Assoco versus Italy, the tribunal explicitly rejected collapsing a company into its shareholder, reasoning that separate legal identities can have independent abilities to exercise rights, own its own assets, incur obligations, and be part in any procedural legal proceedings of its own. In this case, Landonis is the operating company that holds 100% of Kokura Green. It is a party to the PPA and was directly subject to the seizure orders ordered by the Ministry of Energy, whose rights under the NFTA are at stake at this arbitration. By contrast, Hawk Capital is merely a 49 minority shareholder of Landonis, holding no direct right under the PPA, never subject to a seizure order, and never a party to an FTA of its own capacity. Two identities are not identical. The first limb of the triple identity test subsequently fails at the threshold. Therefore, Hawk Capital's prior unsuccessful claim has no preclusive effect on Landonis' claims. To hold otherwise would violate the corporate separateness principle and deny justice to the company itself. Therefore, the objection of res judicata should be dismissed. Furthermore, the claimant turns lastly to collateral estoppel objection. As established in Lao Holdings versus Lao PDR, the most important element of the collateral estoppel is the party facing estoppel must have a full and fair opportunity to contest the prior decision. In this case, as previously established that the identities are different, the claimant could not have been a party to the arbitration between Hawk Capital and Mustafar. As a result, the claimant did not have a full and fair opportunity to contest the findings of the court of Mustafar, or the court of, to the court of Hawk Capital versus Mustafar. Therefore, the objection on collateral estoppel correspondingly fails. In the light of the foregoing, the claimant respectfully requests that this arbitral tribunal declare that it has jurisdiction over this arbitration and the claimant's claims are admissible. If I may not assist the court any further, I conclude my submission. Thank you.
Okay, Counsel, even if we accept that Lando is a separate legal entity from Hawk Capital, right? The evidence, some shows in the news that your executive authorized a payment to PM Vanachai, so that for some services that he got, and then if the very admission that your investment into Mustafa was procured a violation of international public policy, meaning bribery, in that case, so just on what basis does this tribunal would have authority to protect and cover investment which might come from illegal and at its inception? So could you please elaborate on this?
Thank you, Mrs. Arbiterator. We have noted your concern, and we clarify that actually the finding of the Mustafa Supreme Court in PM Vanachai case or in Hawk Capital never addresses landowners' participation or its knowledge of bribery. It addressed only some of Gokura Green's executives. Yet, the respondent has failed to draw a connection between Gokura Green's executives and landowners' participation in bribery. In this response to RFA, thus, the verdict of Mustafa's internal court on PM Monachai or the Hawk Capital arbitration is not an evidence of landowners' involvement in corruption. It's only Gokura Greens at best. And furthermore, even if, as Ms. Arbitrator have asked, even if the corruption did occur, I would like to point the tribunal's attention to the fact that this is not the case that has the legality clause in the treaty. As established before, that the NFTA has no legality clause. Therefore, it does not discard the investment from protection for any illegal procurement. Does that answer Mrs. Arbitrator's question? Thank you. I conclude my submission. Thank you.
The second counsel for the claimant, if you are ready, then please proceed.
Yes. First of all, may I check whether am I audible?
Very fine.
Thank you. Mr. President, member of the tribunal, my name is Athipa Jalanbandit, and I continue the submission on behalf of the claimant, Landowners Green Incorporated. My co-counsel has established the jurisdictional basis of this claim. So now I will address the merits and compensation. Member of the tribunal, to begin with, it is necessary to establish that Article 4 of the Responsibility of State for Internationally Wrongful Acts, or ASIWA, has stated that all legislative, executive, and judicial are considered as state acts. Therefore, in this present case, the interim measure rejection by the court, the forfeiture by the President-May government, the enactment of CBBA, and also the PPA infringement by MEG are all attributed to Kingdom Mustafa action. Consequently, the claimant brings this action against the respondent, Kingdom of Mustafa, on the following three submissions. First, that the respondent breached the fair and equitable treatment, which I will call it FET standard, breaching Article 7 of the NFTA. Second, that the respondent dismantling of coal sector constitute an unlawful indirect expropriation, breaching Article 10 of the NFTA. And my last submission is that the respondent is obligated to pay full reparation in amount of 350 million USD, plus sunk investment costs, compound interest, and also the legal costs related to this arbitration. With the tribunal permission, I shall turn to my first submission about the breach of FET standard. According to the United Nations Conference on Trade and Development series on issue in International Agreement 2 has established that FET is breached when a state conduct its denial of justice, discriminatory, and failure to protect legitimate expectation. In this case, the respondent has failed on three fundamental fronts. The first and the most important element is the failure to protect legitimate expectation, as Clause 15 of the PPA between Gokura Green and MEG, the Kingdom of Mustafa state-owned enterprise, is an economic equilibrium clause that requires the government to compensate an investor to restore the original economic balance of the project whenever amendment of law occurs. In CMS v. Argentina case has ruled that this economic equilibrium clause grant an investor a legitimate expectation. In this case, this clause, PPA clause 15, that show that Gokura Green, the claimant, should have been protected by legitimate expectation. Conversely, the respondent dismantled this very expectation. Despite the PPA 30-year term, the respondent enforced the CBBA immediate seizure, terminating that 30-year term. This is called the frustration of the claimant's legitimate expectation, breaching the FET standard and also breaching Article 7 of the NFTA. The other component that the respondent has breached in this case is the denial of justice, Because as in ASEAN v Mexico case, it has clarified that the denial of justice is occur when a court refuses to entertain a suit and manifest injustice, leading to an outcome which offends a sense of judicial propriety. In the present case, when the High Court rejection of claimant application for interim measure by explaining that ministry action is already in line with the CBBA, this is considered a denial of justice. Not only did the court fail to ensure that the claimant had a meaningful opportunity to present its evidence, but was also not able to provide reasons comply with a sense of judicial propriety. Therefore, the rejection of interim measure was considered a lack of due process and denial of justice also.
Counsel, granted that the conduct of act of state, including the judicial act, but when you consider the fair and equitable treatment of an organ of the state, do you give different deference if the act was from the judiciary as against the executive? Does the court or judiciary get certain deference or respect from the tribunal than the executive?
Both executive and judicial is considered the same act of state, as stated in the Article 4 of the ASEAN.
Yes, we granted that, but the different deference. Let me give you an example. Well, everybody in the common law world knows that hard cases make bad law. So perhaps you instead of starting from cases, you might go to the rationale or the reasoning of those cases. Like for instance, in the exit here, there's a case by the American pharmaceutical company Eli Lilly against Canada, and then the acts in question were the decisions of the Supreme Court of Canada in invalidation of certain patents from Eli Lilly. But then the court, the tribunal, gave deference. Well, this is the court, and you may have all civilized nations, the judiciary is put in a greater respect than other organs. Do you agree with that decision, that ruling, or not?
May I have some second before answer your question, please? Thank you.
You may. The Secretariat might give some more time added for the claimant, because this is the problem that put to the claimant by the tribunal. Sorry.
We noted your concern. To answer your question, I understand that the judicial is the court has the discretion to decide the case, but now we are argue with the discretion of the court that has used the different sets of rule to the same factual reality. So now we are argue with the discretion of the court, which is also exercise one of the branch of sovereign power, as stated in the ASEAN Article 4.
Of course, yes. But then let me ask you another question. There's a certain case that went to arbitration, but it has now been settled. It is about the Australian investor in a certain country called Thailand. But the the injunction to stop the investor from conducting the mining business, injunction is from the Prime Minister exercising the executive power. Would you have thought that the tribunal might give different perspective of deference if the injunction were given by the competent court?
I cannot assist. To compare with the case that the tribunal has mentioned, I admit that the court has the discretion to decide the case, but the court has more discretion more than this case, because this case is just to decide for the interim measure, but that is the decision for the award of the tribunal.
Right. Thank you for your attempt. Go on,
May I proceed?
please.
Now I will move on to my second submission about the indirect expropriation. Under Article 10 of the ANFTA has stated that the respondent is prohibited from taking measures equivalent to expropriation without compensation. In addition to direct expropriation, there is also an indirect expropriation. First of all, may I turn the tribunal attention to the page 23 of the Moot problem. In an Annex 11B, paragraph 3B, has defined that an indirect expropriation is considered when the government action breach the government prior binding written commitment to the investor. In this case, PPA and CBA is both considered a prior binding written commitment to the investor. Breaching this contract meets the definition of the indirect expropriation already. And the enactment of the CBBA, which mandate the permanent cessation of all cooperation, render our facility economically useless. This is meet with the definition of the indirect expropriation mentioned in the case of Metaclad v. Mexico case. So with all of this, the respondent action has meet with the indirect expropriation definition, breaching Article 10 of the ANFTA already. While expropriation may be subject to certain legal exception, the respondent action do not meet the criteria at all. To illustrate, although it may seem like PM may enact CBBA for public purpose, in fact, her action was done just to object her rival party, PM Wanachai. Mr. President, member of the tribunal, may I turn your attention again to the exhibit R10 of this article. This article shows that PMA has no real intention to transform green policy into reality. Even if the tribunal were to decide that it was for public purpose, PMA action was not done in non-discriminatory manner and failed to accord with due process of law. Especially, prompt, adequate, and effective compensation was not made. Without compensation, an action was subjected to the breach of Article 10 of the NFTA. Having established that the respondent failed to meet FET standard and expropriated foreign investment, we now move on to my third submission, the legal consequence of this breach. The claimant has submitted that the respondent is mandated to provide full reparation in amount of 350 million USD. Because the first reason is that as the respondent action is considered an international wrongful act, the respondent must grant full reparation according to the ASEAN Article 31. The principle of restitutio in integrum has established in the Faculty of Social Case state that full reparation refers to the reparation that wipes out all the consequence of the illegal acts and re-establish the situation which would have happened if that act had not been committed, not just scoping to the fair market value standard which was found in the Article 10 of the ANFTA. Because the Article 10 of the NFTA, which requires the fair market value standard, this is only applied to the lawful taking. So when the respondent conduct is indirect expropriation, which is unlawful measure, it is considered an an internationally wrongful act falling outside the scope of ANFTA. So fall in the scope of ASAIWA Article 31, require the full reparation. For full reparation, the claimant submit that DCF method is the most appropriate valuation method because, first, DCF method is suitable for going concern, like Pacinta's plant situation. And second is that DCF concern both actual loss and loss in the future profit, fulfilling the full reparation principle. As the tribunal in CMS v. Argentina case has affirmed that DCF is the standard valuation technique for going concern with proven sufficient operational history to provide rational future protection. So does the Pacinta's plan. It is categorized as a going concern because it has operated successfully and profitably for 12 years. By being able to calculate future cash flow, DCF will enable the claimant to meet the goal full reparation. Another element of the full reparation is the sunk investment cost. Before being forced to permanently terminate coal power generation, 150 million USD was invested for Pacinta's plant upgrade. This expenditure, called sunk investment cost, representing an actual loss, one of the elements of full compensation. Therefore, the respondent also has a responsibility to cover this sunk investment cost. Member of the tribunal, the final element required to achieve the standard of full reparation is the inclusion of compound interest. Compound interest will enable the claimant to restore the time value of the money from the moment that the respondent forced the claimant to exit the market in May 2024 until the final award is paid. The claimant lost ability to deploy that capital elsewhere.
Counsel,
Yes.
you request the you argue that the claimant was induced into this transaction by the fraudulent act of the highest executive of Mustafa himself, the Prime Minister, no less. But yet, being a professional in this industry, the energy industry, obviously before you enter into this venture, into this project, due diligence must have been exercised. And obviously, one must foresee that the prospect of green energy, clean energy is always there. So maybe one day the world certainly or should have aware that coal energy is not that clean or environmental friendly. So there must be alternative to coal, greener energy, nuclear power, wind and solar power. If you expect those competition, how should one take those very foreseeable things into calculating the prospective loss?
Yes, thank you for the question, Mr. Arbitrator. First of all, we understand your concern, but as the PPA has explicitly stipulated that Gogora Green shall sell 2,300 megawatts of electricity to MEG every year. This is show that we have legitimate expectation from the revenue for 30-year term of PPA. So the claimant projected revenue is already guaranteed by this PPA already.
Thank you. Go on.
And also, moreover, to clarify more for your question, in the public document by Fortune Business Insight has shown that the coal power has continued to rise. Coal usage continue to rise.
Yes. You could have also cited the war in Middle East, yeah? All right. Go on.
Thank you. To proceed with my last submission is about the expense arising from this arbitration. The claimant has submitted Kingdom of Mustafa should bear all of the arbitration costs because litigation tax is considered a part of full reparation. If the claimant must absorb this expense itself, its 350 million USD recovery is effectively diluted by a litigation tax, leaving the claimant poorer than it would have been if the respondent had complied with the treaty, which will not accord with the principle of full reparation. And another reason is that this arbitration arose solely because the respondent refusal to negotiate. As in Rusali v. Romania case has stated that the refusal to negotiate is a critical factor in cost allocation. So in this case, the claimant submit that the claimant has already sent the letter asking for negotiation to the respondent already, but the respondent ignored. May I have more 1 minute to conclude my submission? Thank you. So when the claimant has submitted a letter asking for negotiation, but the claimant ignored, this is called that the respondent has refused to negotiate. So the respondent should bear all the arbitration costs. Member of the tribunal to submit, the respondent asking the tribunal to do what the local court would not, hold Mustafa accountable on all three issues that the claimant submit. First, hold that Mustafa has breached the FET standard, breaching Article 7 of the NFTA. Second, hold that Mustafa has committed an indirect expropriation, breaching Article 10 of the NFTA. And the last one, this breach gave rise to the full compensation under international law in amount of 350 million USD, plus some investment costs, compound interest, and arbitration costs. If I may not assist the court any longer, with all this reason, I submit my
Counsel,
submission.
I have
Thank
questions
you.
for you.
Yes.
Well, actually, I just wonder whether the going concern of Pacinta's plant, just a speculative one or a certain one, just one thing. And then under Article 10, actually an expropriation or a seizure, or the measures that you think are equivalent to a seizure of Lando, and then actually Lando sold its assets to a private company, BioBuild, right, for 50 million US dollars. Well, actually, since the state did not take title from your plant and you receive a payment from a third party, okay, so I just wonder, isn't that simply a case of a poor market at the time that you got only $50 US dollar, rather than asking for base your ground on a state-led expropriation?
For the first question that Ms. Arbitrator has stated that our revenue is not guaranteed and speculative. As I mentioned before, that we have the PPA clause 10 that guarantee that we have to sell the exact number of the electricity to MEG every year. So this is already guarantee our revenue already. And when to comply with the full reparation principle that I mentioned before also, when the respondent has committed internationally wrongful act, they should grant us the compensation which wipe out all the consequence and re-establish the situation which the breach of the treaty had not been committed. So they have to comply with the PPA as it had not been breached before. And for the second question about the expropriation, this is considered an indirect expropriation, not a direct expropriation, because there is a definition of indirect expropriation mentioned in the Metalclad v. Mexico case that it is occur when the state does not take the title, but its measure leave the investment useless or significantly diminish in its value. So in this case, when the respondent has forced closure, is also considered that the respondent has made our investment diminish in our value, meet with the definition of the indirect expropriation. Moreover, as the Miss Arbitrator has mentioned that we sold by voluntarily, we do not admit that we sold by voluntary because according to the CME v Czech Republic case, is the case that established that when the states had enact new law that put the pressure on the investor, the action that the investor decide to sell the investment out is not considered a commercial choice because it was done under the state pressure. So in this case, the enactment of CBBA made the claimant left with no choice, and the claimant only specialized in the coal power plant. So this is almost impossible to generate, and so the claimant is almost possible to generate the income from the other choice. When left with no choice, combined with the state pressure, this is not a commercial choice.
Counsel for the respondent is ready, then you may go.
Good afternoon, Mr. Presiding Arbitrator and honorable members of the tribunal. My name is Nacha Suryapanich, appearing on behalf of the respondent along with my co-counsel, Milan Chinakot. Both my co-counsel and I will be speaking for 20 minutes each. I will be addressing the first two claims regarding the jurisdiction and the merits, while she will be speaking on the last two regarding the damage and compensation. I make two submissions. First, the arbitral tribunal lacks jurisdiction over the claims brought by the claimant, and the claimant's claim are inadmissible. My apology. And second, the respondent has not violated Article 7 and Article 10 of the AAN Free Trade Agreement, or AAN FTA. I will now address the first submission that the tribunal lacks jurisdiction because the investment was obtained through corruption, objecting the rationale material. The respondent submits that the claimant's investment does not qualify for protection under the AAN FTA and the Exit Convention. It is a well-established principle of international law that investments obtained through corruption, bribery, or fraud are contrary to the international public policy. According to the Plama Consortium Limited versus the Republic of Bulgaria, the tribunal stated that an investor who enters a host state through fraudulent conduct or in violation of domestic law cannot rely on treaty protections, including legitimate expectations. A claimant who approaches a tribunal with bad faith cannot demand the protection of international law and treaty. In this case, the claimant cannot demand the protection due to corruption. The factual record demonstrates that the claimant's entry into the Malta-Foreign market was illegal, involving the former Prime Minister Mr. Wanachai, who was convicted of corruption. Under the guise of consultation fee, the investigation by the Special Committee on Corrupt Dealings revealed that Gogora Green funneled substantial sums to consultants connected to high-ranking officials, including the brother-in-law of Mr. PM Wanachai. These payments has no legitimate commercial purpose and constituted bribes to secure the Favorable Power Purchase Agreement, or the PPA, and the Coal Business Act, or the CBA of 2010. Since the rights forming the basis of the claimant's investment were secured through criminal acts, they are legally void. Consequently, this tribunal lacks jurisdiction over claims deriving from the corruptly procured PPA. Currently, the claimant is being prosecuted by the Kingdom of Mustafa. if the claimant has truly not been engaging in the corruption, the claimant would have submitted a statement of defense to the criminal court without delay. By delaying in justifying the company's innocence, this would only harm the claimant company image. Continuing on, regarding the res judicata objection, it requires a failure to satisfy at least one of the three conditions laid by its triple identity test. The test condition concern the identity of parties, identity of subject matter, and identity of course of action. In this case, the claimant, who is under Hawk Capital full control and whose 49% of the shares were held by Hawk Capital, is going against the Kingdom of Mustafa like Hawk Capital previously did. Additionally, the claimant and Hawk Capital submits the same claims in the arbitration, relying on the same legal and the factual grounds, which has already been dismissed in another arbitration. These facts satisfy all three conditions requiring this tribunal to dismiss this case. Moving on to my second argument of my first submission, even if the tribunal were to overlook the corruption, it lacks jurisdiction because the Kingdom of Mustafa's consent is conditional upon strict compliance with Article 20 and 21 of the ASEAN FTA. Article 20 requires parties to resolve disputes through consultations, and Article 21 states an investor may submit a claim only if the dispute has not been resolved within 180 days of the receipt of a request for consultations. These are mandatory jurisdictional conditions required to perfect a state consent. The claimant's notice of 4th April 2025 was a bare notification devoid of the necessary legal and factual details required by the Article 20, as it only mentioned the dissatisfaction with the recent change in the government. The claimant only provided sufficient information on 15 May 2025 upon the request from the respondent. Calculating from this valid notice date to the filing of arbitration on the 1st October 2025, the period consists only of 139 days. By filing the request 41 days earlier, the claimant violated the treaty. The respondent's consent was never perfected, and the tribunal does not possess jurisdiction. Therefore, we submit that since there is no compliance, this tribunal has no authority or competence to hear this dispute, stripping the jurisdiction. I will now address my second submission regarding the merits. The respondent has...
Before we go to the merit, the respondent claims that the case or the dispute was brought by the claimant with tainted cause because of the corruption involved in inducing the claimant into this transaction. But if that was a defect, was it not the defect partly come from the respondent as well? It was induced not least by the highest executive of the respondent, the Prime Minister. So in any case, that was something who represents the respondent. What would you say to that allegation that you are a part to blame? And if the principle of you come to court with clean hands isn't derived from equitable principle, and equity is very much the discretion of the tribunal, how would you persuade the tribunal to refuse its jurisdiction when there's a part of you in that form?
We submit that we do not deny our previous PM Wanachai action of corruption. After we have found the evidence of the corruption conducted by him, we immediately convicted him of corruption and sentenced him subject to the punishment according to the Section 7 of the Anti-Corruption Act of the Kingdom of Mustafa. Nonetheless, since it is still a corruption, according to the Plama and Consortium Limited versus the Republic of Bulgaria, the investor who entered the whole state through the fraudulent conduct and in violation of the domestic law cannot rely on treaty protection of the treaty that the party have signed to. It is very convincing that the claimant has conducted corruption. According to the facts, page 50, paragraph 10, it is stated that in order to secure a package deal of highly demanded license and long-term contracts with Mustafa Energy Grid, many coal-fired power plant operators, especially foreign-owned, engaged in so-called lobbyist activities and paid approximately USD 40 million to consultants connected to key high-ranking public officials. Thus, this is reasonable to believe that many coal-fired power plant operators were involved in corrupt dealing involving former PM Wanachai, who has already been sentenced to the court. Plus, Lando, the claimant, has already participated in the private talk with the PM Wanachai after his press conference and decided to invest in the Kingdom of Mustafa.
So, Council, in that case, like Mustafa accepted that Lando's Capital 4, accept Lando Capital for a decade and actually awarded Laguna Green with a PM Excellence Award in 2013. And actually, as you said, that is a corruption, right, from Mr. PM Wanachai. So if your state officials participated in a corruption, can you, as state, conveniently invokes your own internal malfeasance to invade from the chart? So like you are effectively like benefit from your unclean hands.
We acknowledge that the PM Wanachai has granted the claimant an award regarding the power plant. However, we submit that even if it affects the clean hand principle, it is still the objection a matter for the merits and not the jurisdictional bar. Under the principle of competence, this tribunal has the authority to determine the jurisdiction. The allegations of legality were established, and it would pertain to the conduct of investment rather than the existence of the investment. Thus, the tribunal can exercise the jurisdiction to consider the facts of the case. If I may continue with my proceeding, I will now address my second submission regarding the merits. The respondent has not violated Article 7 and Article 10 of the AAN-FTA. The respondent submits that the claimant did not have a legitimate expectation that the Kingdom of Mustafa would have maintained a predictable and stable legal framework. As noted in Mazda and Parkerings, an investor must exercise appropriate due diligence. The claimant reliance on a single speech by a politician and a private talk does not amount to due diligence. During negotiations, climate change was already a highly discussed issue, and the respondent enacted the Coal Business Ban Act, or the CBBA, in preparation for COP26. Since the COP26 is happening, we would like to adopt the change as soon as possible, as the ICJ has already been discussing the climate change issue. Also, as referred to by the Claimant's Council, I would like to bring the Tribunal's attention to Clause 15 of the PPA.
So, Council, before you go, could you please elaborate more on the ICJ advisory opinion that you just mentioned?
In delivering its unanimous opinion, the court described the climate change as an urgent and existential threat, as it states the state's international obligations. The ICJ maintained that they have a duty to prevent significant harm to the climate system by exercising due diligence and using all means at their disposal to prevent activities carried out within their jurisdiction or control from causing said harm. The court further asserted that the breaches of any of the obligations identified in the opinion could potentially constitute an international wrongful act, thereby potentially engaging in the international responsibility of the state concerned. If I may refer back to the Clause 15 of the PPA, the text explicitly states any change in law, regulation, or governmental policy. This shows that the claimant should have been aware that the respondent could make changes. We would like to also refer to the Parkering versus the Lithuania case. It is an exit case. The tribunal held that investors must be aware that there is a potential for the legal environment to change. Due to this, investors must structure its investment to be able to adapt when it does change. Proceeding to my second argument of the second submissions, the respondent has not expropriated the claimant's investment under Article 10 of the AAN-FTA. It was a valid exercise of police power under Annex 11B. The respondent obligation under Article 10 is never triggered. Annex 11B, paragraph 3, subsection A, explicitly states that an adverse economic effect standing alone does not establish an expropriation. While the claimant alleges loss, they retain fundamental ownership. Per the Housing Corp test, the rights were not useless. The claimant kept legal title and physical assets, eventually selling their stakes for an insignificant USD 50 million. This residue value proves the derivation was not total. Annex 11B, subsection C, also explains the character of the government action. This includes the objective and whether the action is disproportionate to the public purpose. The CBBA did not target the plant, it regulated an industry in order to align with the international standards, as demonstrated by the BioBuild's successful conversion. The asset remained viable, the claimant simply refused to adapt. Additionally, Annex 11B, subsection D, explained the non-discriminatory regulatory actions by a party that are designed and applied to achieve legitimate public welfare objectives, such as the protection of public health, safety, and the environment, do not constitute expropriation of the type referred to in paragraph 2, subsection B. As evidenced in the Exhibit C8, the number of infants and children who suffered neurological and developmental issues increased twofold. The department suggested that there were several causes of the change, but one concerning issue was the deforestation in the watershed forest in the Joseph Basin. In addition, the respondent measure does not amount to indirect expropriation. As established in LG and E, the tribunal considers the extent and duration of the measure. In this case, the CBBA did not render the investment useless. While the act bans coal businesses, Section 7 still allow existing operators to operate from sources other than coal. The claimant could have converted the plant to biomass as BioBuild did, but refused the 1.5-year transition period. The High Court decision does not constitute expropriation. Such a claim can only succeed if there is a denial of justice. The court treated the claimant and Coal Supreme differently for legitimate reasons, as the claimant failed to provide an expert report from Professor Shiu Bako to prove an imminent threat. The claimant could have appealed to the court, providing more concrete or convincing evidence. The claimant chose to not act accordingly. Moving on to my last argument, even if the tribunal has found that expropriation has occurred, the measures complied with Article 10 requirements is complied by the respondent. First, the measures for public purpose align with the global standards to phase out coal, similar to bona fide intention in Methanex. Second, the measures were discriminatory, as the different court outcomes were based on reasonable justification and evidence. Third, regarding compensation, no payment was needed as the investment was illegal from corruption. Finally, the respondent acted in accordance with due process, as the claimant had full access to judicial remedies, but chose not to continue the proceedings until the merits phase. In conclusion, I would like to submit that the arbitral tribunal lacks jurisdiction over the claims, and the claimant's claims are inadmissible due to the corrupted investments and failure to comply with the preconditions. And second, the respondent has complied with Article 7 and Article 8, Article 10 of the AAN-FTA. This concludes my two submissions.
You mentioned about our lack of jurisdiction due to the claimant not complying with the cooling off period. Yes. Granted that you're right. What's your relief sought from us? Would you like us to dismiss the whole claims from the claimant, or you just need us to stay the proceedings for that you and the claimant can go to the proper channel of consultation?
We submit that we would like this tribunal to dismiss the case entirely and send the parties, both respondent and the claimant, back to the consultation period. If the claimant and the respondent has complied with the condition, the 180-day cooling off period, the respondent would agree that the dispute can be brought to arbitration if the dispute hasn't been resolved yet.
Also for the respondent, please.
My name is Milan Shinakot, and I am representing the respondent in this present case. I make the last two submissions that first, the respondent does not have to pay the claimant any damages or compensation. Second, the claimant must bear the cost of this arbitration. I now move to the third submission, that the respondent has no obligation to make reparations since no breach of the AAN Free Trade Agreement, which will be referred to as AAN-FTA, has been established, and that the claimant's request for compensation must be dismissed in its entirety. However, even assuming that a breach was established, the claimant still bears the burden of proving compensable damage that are certain and directly attributable to the state's conduct, and not damages resulting from an investor's own commercial decisions or exposure to market risks. International law does not presume damage from the mere existence of a change in regulatory measure. Compensation is limited to injury that is legally cognizable, non-remote, and directly attributable to the state's conduct. This is supported by Article 31 of the RCWA. Where the claimant fails to prove this damage, no obligation of reparation would arise even in such circumstances. On this submission, the respondent advances four arguments. First, the claimant has failed to establish the existence of compensable damage. Second, there is no attribution of conduct to the respondent. Third, the alleged loss arises from the claimant's own decision to dispose of its investment. And lastly, the discounted cash flow method is inappropriate for valuation in this present case. The respondent first submits that the claimant has failed to establish the existence of compensable damage under international law. According to the facts, prior to its divestment, the Pacintas plant remained in existence and the claimant retained full ownership of its shareholding in Gorgora Green Energy Incorporation. The absence of any compulsory transfer or expropriatory act confirms that the claimant did not lose an existing asset as a result of the respondent's measure. Furthermore, it must be emphasized that at no point did the respondent order the closure of facility, revoke the claimant's title, or compel the transfer of the investment. The absence of any formal deprivation further confirms that the claimant's alleged loss consists of a change in economic circumstances which is insufficient to establish compensable damage. A long-term investment in regulated sectors inherently involves exposure to regulatory change, which forms part of the ordinary commercial risks assumed by investors. Therefore, a mere change in regulatory or economic condition does not constitute compensable damage as recognized by the tribunal in the Parker-Rings case, which the tribunal held that investors must be aware that there is potential for the legal environment to change. Hence, investors must structure their investment to be able to adapt to these evolving regulatory changes. Secondly, if I may bring your attention to the facts that in the present case, the respondent has also provided the claimant with opportunities to adapt its investment to the evolving regulatory framework. These options were consistent with the respondent's energy transition policy and were available to similarly situated operators as well. The claimant, however, decided not to pursue such offered alternatives. Instead of adapting its business model to new regulatory environment, the claimant chose to maintain its existing operations and subsequently divest from its investment. According to the facts, BioBuild was able to successfully adapt and convert the Pacintas plant to comply with the CBBA. This further proves that the divestment was not the only option available for the claimant. The economic consequences do not constitute compensable damage in such cases where an investor declines reasonable opportunities to adjust its operations. Therefore, any alleged loss resulting from the claimant's failure to adapt cannot be attributed to the respondent. Proceeding to the second argument that there is no attribution of conduct to the respondent. While the respondent acknowledged that the conduct of state organ can be attributed to the state under Article 4 of the RCWA, however, in this case, it was the claimant's fault that they failed to provide the necessary evidence, unlike Cole Supreme. Secondly, there was an option to appeal to the claimant, but they chose to accept the judgment of the domestic court. Therefore, this refusal of interim measures cannot be attributed to the compensation claimed by the claimant. Furthermore, we submit that the refusal of interim relief by domestic courts cannot be attributed to the respondent as executive conduct. This is supported by a principle affirmed in the Jandanol case that judicial decisions by independent domestic courts constitute acts of the judiciary and are not automatically attributable to the executive branch of the state. The tribunal in that case held that the refusal of provisional measures by domestic courts did not amount to an internationally wrongful act attributable to the state, and it displaces the claimant's own commercial decision as the proximate cause of the loss. Moreover, the refusal to grant interim relief did not compel the claimant to divest from its investment. The absence of interim measures neither rendered continued operation legally impossible, nor transformed the claimant's voluntary divestment into a consequence of the respondent's conduct. Without a sufficient causal link between the respondent's measure and the alleged loss, the respondent cannot be held liable for the damages claimed. Third,
So, counsel, I just wonder, you justify the High Court's differential treatment, right? With pointing out that an expert report, Chubako report, provided by Co-Supreme, but not by Lando. So that's why the High Court granted the injunction to Co-Supreme. But considering the full protection and security standard, shouldn't that the state administrative organs has the duty to investigate the economic impact or the health impact of the closure of the Pacintas plant, rather than put all the burden to the claimant, which are just a private entity?
Yes, Madam Arbitrator, but the respondent urges the tribunal to see Exhibit C8, which, according to this exhibit, there is an increase in 30% in patients with lung cancers, 5-time increase in patients with asthma and COPD, increase of infants and children with neurological issues, and including the environmental issue that rainfall decrease, leading to more flood when it does rain. The CBBA is enacted due to this urgent necessity of the state to preserve its environment and the public health of its people. Returning to my argument that third, we submit further that the loss arises from the claimant's own decision to dispose of its investment. The respondent did not order the sale or immediately stop its investment in the Pacintas plant. The decision to divest was taken unilaterally by the claimant and therefore constitutes a voluntary commercial decision. Such a decision amounts to an independent act that breaks the chain of causation. Moreover, the facts indicate that at the time of the divestment, criminal proceedings were pending in the Kingdom of Mustafar in relation to the claimant's conduct. From the facts, the claimant and its executives were charged with corruption, and 9 days later, the claimant announced its sale of the investment. It must be considered that the claimant had almost 3 years to sell or comply with the CBBA. However, the claimant did nothing until the criminal conduct was charged. Hence, the decision to sell was materially influenced by its exposure to potential criminal liability arising from its own conduct. Losses arising from an investor's decision to avoid legal accountability may constitute self-inflicted harm. Other than the timing, the conduct of the claimant further proves that the sale is voluntary. Despite being aware of the CBBA and its consequences in the economic market, the claimant chose not to adapt its operations and continued its coal-based activities. If the claimant truly lacked the ability to adjust, it would have withdrawn from the investment at an earlier stage. This firmly held position of the claimant proves that they were never actually threatened by the respondent's repeated notice of possible cessation and closure over the years. Thus, the claimant cannot argue that our possible seizure rendered the sale of the investment involuntary. Such losses, therefore, fall outside the respondent's regulatory measures and cannot be regarded as a normal or foreseeable consequences thereof. As it has been established that the alleged damage is not attributable to the respondent, no obligation of reparation may arise. Consequently, there is no need to assess the appropriateness of the valuation method. However, should the tribunal find that causation is established, the respondent submits in the alternative that the DCF method is inappropriate in this present case. DCF only applies where a business has a stable record of profitability and future cash flows can be projected with reasonable certainty. While the claimant has operated for over 12 years, the relevant question is not merely the duration of operation, but whether the business demonstrates a stable and predictable record of profitability sufficient enough to support reliable projections of future cash flows. It must be emphasized that The nature of the claimant's business is inherently unpredictable, as reflected in the facts under the respondent's notice of arbitration, paragraph 33, that future energy prices are highly volatile and depend on uncertain factors, including the development of the climate policies and the advancement of low-carbon technologies. This renders the discount of 8%, which is used to calculate the investment's project annual returns, unrealistic and highly speculative. In these circumstances, the use of DCF would risk awarding compensation for hypothetical profits rather than proven economic loss. Lastly, we submit that the claimant must bear the cost of this arbitration, which includes the respondent's legal fees and expenses. The conduct of the claimant exhibits a lack of genuine intention to resolve the dispute through consultation, and thus arbitration was initiated in bad faith through the abuse of process. Under Article 21 of the ANFTA, a cooling-off period of 180 days is required before any party can initiate arbitration. There has been emphasis that the purpose of the cooling-off period is not solely for procedural formality, but rather for facilitating opportunities for amicable settlement. The claimant, it was not the respondent who refused to negotiate, but it was the claimant who directly frustrated this treaty objective since their conduct exceeded mere non-cooperation. As they intentionally obstructed the process by refusing to provide any factual information and legal basis, and they failed to give a timely response during the 180-day period of the consultation process. The claimant ensured that the respondent could not evaluate the risk or make an offer. This makes the settlement of the dispute before arbitration impossible. Such conduct proves that the claimant deliberately delayed the consultation process to force the respondent into a costly and unnecessary arbitration procedure when the dispute could have been resolved if the claimant had been more cooperative. Furthermore, there is apparent evidence of the claimant engaging in further abuse of process by filing duplicative claims. The issue in that dispute is essentially the same issue as this present case, which has already been decided in the Hawk Capital versus Kingdom of Mustafar case. By doing so, the claimant is actively using different corporate entities to litigate the exact same laws, in which case such a conduct has been established as contrary to the purpose of treaty protections. The clear unwillingness to cooperate accounts for a dilatory tactic, and the pursuit of duplicative claims of the claimant constitute an abuse of process. As recognized in the Jack's Islands case, that a party's failure to proceed diligently with an arbitration is a critical factor in assessing cost allocations of the parties. In the Jack's Islands case, the tribunal held that they considered the conduct of the parties during arbitration when allocating costs, and the dilatory tactics and lack of cooperation during proceedings are highly relevant factors in determining the cost allocation. Therefore, we submit that the conduct of the claimant demonstrates an initiation of arbitration in bad faith, justifying a full shift cost of the arbitration to preserve the integrity of the investment protection system. For these reasons, the respondent respectfully requests the tribunal to grant the relief sought in its submissions that first, the respondent does not have to pay the damages to the claimant, since there is no compensable damage recognized and the loss or the alleged damage derives from the claimant's decision to sell its investment. Secondly, the claimant must bear the cost of this arbitration. This is because the claimant initiated arbitration in bad faith through the abuse of process as have been established. I will now open the floor to the tribunal's questions.
Well, just like for the expropriation question about the public purpose that you said that, okay, a public purpose can use as a legal ground, but just like is the global phase out of a code sufficient to be a public purpose and justify the total deprivation of value without compensation at all? And if we accept that the respondent argue that environmental protection is a police power, right? Is there any limit to a police power? And is that proportionate, as according to the principle of proportionality, your measures and what happened with the claimant?
May I have a few moments to consult with my materials? Regarding the public purpose of the respondent, it is the host state right to regulate domestic matters in the public interest has to be taken into consideration. It is also in line with the COP26 that my co-counsel mentioned, which is an international standard. The respondent's measures is proportionate as established in AWG versus Argentina, that tribunals have long recognized a state's legitimate right to exercise such powers in the interest of public welfare. The respondent should not freeze the legislation and the respondent should not freeze the legislation because there is a necessity in the environmental and health issues of the state.
Right, so we come to the rebuttal.
Thank you, Mr. President. First rebuttal, the respondent relies on Plama versus Bulgaria case to establish that corruption discards the investment from its protection. Yet, if the tribunal examines the rulings of the Plama case closely, the tribunal will find that there was a legality clause in the BITs between those disputing parties. In other words, they have the legality clause, therefore the protection of the investment must be discarded. But in this case, as the claimant have previously established that there is no legality clause in the FTA, therefore the tribunal cannot discard the investment of its protection. And the doctrine in Plama versus Bulgaria cannot be applied here. And secondly, the respondent still relies on Section 7 of the Anti-Corruption Act, but it did not, but it examines closely. The tribunal will see that nowhere in the article that the giver of the bribe have criminal liability, and they rely only merely on prima facie finding, which does not meet the clear and convincing standard or any standard at all. On the other hand, the respondent has not yet establish any standard of proof. But on the other hand, the claimant have established the standard of proof, which is the clear and convincing standard. So we suggest the tribunal use the clear and convincing standard rather than the prima facie finding, which does not prove anything. And Thirdly, the legitimate expectation. The respondent relies on, the claimant relies their legitimate expectation on the PPA, which is a signed textual contract, not merely on the words of PM Wanashai, as the respondent tried to paint us with. And the action of the PPA, which is from the MEC, which is under the Ministry of Energy, and the act of PM Wanashai himself is attributable to the state of Mustafar under ASEAN Article 4, or even if the Prime Minister is corrupted, the action is still attributed to the state of Mustafar under Article 7 of the ASEAN. And the respondent have claimed that they enact the CBBA because they have international obligation under the UNFCCC. But the UNFCCC was signed since 2005. The CBA from the Prime Minister Wanashai was enacted in 2010, and the CBA was enacted 2021. Therefore, there is almost 20 years time lapsed already before they enact the CBBA. Therefore, the claimant submits that the enactment of the CBBA is merely for the political popularity of PMA and to destroy the legacy of her political rival, which is PM Wanashai. And also, as Mrs. Arbitrator has correctly pointed out, the public purpose has to take into consideration of the proportionality doctrine. In this case, the enactment of the CBBA far exceeds the doctrine of proportionality. It renders entirely the investment of the landowers vacant. And as the police power doctrine requires compensation in all the cases that the respondent have cited, the tribunal clearly stated that police power doctrine requires compensation, yet in this case, the claimant has not been compensated, not a single penny. And also in Santa Elena case, the tribunal explicitly said that even if the expropriation is for the public purpose or for the environment, there is a compensation that must be followed. And also the claimant, the respondent also rejected us on the cooling off period that we did not conform with the cooling off period, Article 20 of the NFTA. Yet the claimant submits that Article 20 requires only factual and legal basis as established in Exhibit R6. The claimant have already provided the respondent with factual and legal basis. What the respondent requires is far more than Article 20 requires. And also, Article 26, Paragraph 7, the latest part, the investor is not prevented from submitting its claim to the tribunal, even if it did not wait for the 180 days. Therefore, the submission of the first counsel of the respondent that the tribunal should discard at all the claims of the respondent, of the claimant, my pardon, is inadmissible and contradicts with the doctrine under the NFTA and public international law. Thank you. That is the end of my rebuttal.
Firstly, regarding the res judicata, we still believe that they satisfied the same identity of the parties. Since Hawk Capital is a venture capital in practice demands large sums of shares and management of the company. The facts did not indicate whether the remaining 51% is the majority of the shares or not. Therefore, we submit that it is a safer presumption to presume that this 49% of the shares is the majority, or at least have some control over the company. Secondly, regarding the ruling, to truly prove innocence, the claimant should submit a statement to defense to clear their name. However, investigate reporters went to the registered office and found that it was closed for months with court papers and other official legal documents lying on the floor inside the vacant office. Moreover, the special committee has secured enough credible evidence to justify formal court filing. While the trial is pending, the committee expects a conviction and just punished for the accused. Thirdly, regarding the preconditions, if the claimant was genuinely interested in consulting with the respondent, the claimant would not have turned up to the 13 June 2025 physical consultation unprepared. The respondent even reached out to the claimant on the subsequent meetings after the failed meeting. However, the claimant has never replied or gotten back to us, immediately filing for their request for arbitration on 1 October 2025. By not complying with condition, destroyed the party autonomies, these agreements would have no purpose. In relation to the expectations based on the PPA, regardless of the clause 15 in the PPA, the claimant should have expected a change in the regulatory measure. And second, secondly, Clause 15 states that in the event that any change in law, regulation, or governmental policy materially affects the economic equilibrium of this PPA, this indicates that the law or the regulation can change. As one of Lando's main investor, Hawk Capital, seasoned investor who has been in this business for a couple of decades and has investment across the continent, the claimant should know well that changing of business and regulatory environment is a fact of life. In Saluga Investments, the tribunal held that no investor may reasonably expect that the circumstances prevailing at the time the investment is made remains totally unchanged. In Chemtura Corporation, the tribunal in this case stated that the reasonable regulatory action, in particular when human health and the environment are at stake, even if economically detrimental to a particular investor, are by their nature not likely to be considered as investment breaches. Lastly, regarding the claimant's statement that the enactment of the CBBA was a political purpose, we submit that this enactment of the CBBA was driven by the urgent and absolute necessity of the state to preserve its environment and its people, as shown in the Exhibit C8, that the issues were extremely severe. And we further submit that it is in line with the COP26 and the ICJ advisory opinion. We do not base the CBBA on these international obligations. And that concludes our sur-rebuttal.
Thank you very much. We have some sort of final question from the Honorable Arbitrator, Mr. Rattakon.
Thank you, sir. Actually, it's not a question, but just a few comments here for both teams. I think I was very impressed with the action from both teams here. We are in a dispute regarding the investment treaty dispute or arbitration here. I think more often that we refer to the FET point or FET issue, which is the fair equitable treatment here. Is if I may, actually the FET issue here is very often used for the the investment treaty arbitration here. Not only the respondent but also from the claimant side to argue to each other here. I think when you come to the point where you would need the benefits from the FET issue, I think you need to be very, very clear about what exactly your argument is. For example, if you are the claimant, which is the investor, you would need to convince the member of tribunal here to understand that you are treated unfairly. You never ever got the freedom of the discrimination. The act done by or committed by the host state are basically unfair or not under the due process or transparency, and that sort of action from the host state basically what you call dispute with the legitimate expectation from the from the investor point of view. So you need to come up with the idea as to how to balance between the investor protection versus the the host state power to regulate. So you need to convince that which one that you like us to believe in you. And the other issue is that when you come up with the the quantum issue, which is very important here, speaking for the claimants, you always have the burden of proof for the quantum issue. You are saying that you would like to get more and more, and the respondent argues that actually the future cost that you are claiming here is very speculative, is uncertain basically. So sometimes or somehow you need to come up with if you like to, you need to come up with the modules saying, look, actually there's not only the future cost that you are claiming for, even the DCF cost that the respondent are disputing with. You can compare with the modules, for example, the two modules which might be maybe very close to each other, and then you can convince the tribunal, the member tribunal, even though the future cost is a bit too high, so speculative. But again, the CCF method may be close enough to the future cost. So that's something that would give some rooms for the tribunal to understand your claims, and then put the burden back to the respondent, to disprove that actually the DCF and the future cost are basically far behind to each other. So that kind of thing that you can expand your argument here. And lastly but not least, I think I can see that the two teams did a great job. But one thing that I like to comment here is the confidence. I always see you look at the the script that you try to present your case. The hearings, speaking for the hearing itself, is about the presentation. How to, within the limited time that you are given, how to impress the member tribunal by way of your presentation. Convincing them. Very very important things that you have to always keep in your mind that you even though you don't know exactly what your answer would be, you just cannot answer right away to the question from the tribunal or from the rebuttal or sur-rebuttal, whatever. But you have to keep your own confidence, showing that you are confident enough to rebut to each other or answer the question properly. So anyway, good luck to both of you, both of teams.
Thank you. That was a great advice from Mr. Latakan Bunner from Watson, Ferry and Williams. Now, you cannot go away without a great piece of advice from the Honorable Pakita Nipawan Chod Gitikun, who received her legal education primarily from France and in the UK, and now a judge at the office of the President of the Supreme Court, and she worked so hard together with the Honorable Judge Sarawit over there to make this happen. So maybe say a few words, please.
Thank you. So actually, it has been like a privilege for me having you here today. And actually, we come so far, we are 2 days, just not only 2 days, but before we have a memorials. I've read all of your written memorials, and I just chose 8 teams to come into this moot court, right? So that's a very great pressure that you are here, and you should be proud of yourself, And of course, as Mr. Ratakan said, poise and style are very important in the high-setting tribunal. So it has an impact to the judges, also to the other your opponent you know, like, and then like, I noted that with great interest that some of you advocates with the flow of the argument. That was great, you know. Like you prepared something with your written memorials, and then as the rule said that you are not bound by the written memorials, and then you have to listen to your friends, and then like you just rebut, sur-rebut, and that is how the thing goes. That's the fun of the game, right? So well, congratulations to all participants and for these brilliant final rounds. Thank you very much.
Thank you, Honorable Pakita. Well, for me, sitting in these 2 days with some of the most brilliant mind in the legal field, I feel now I'm convinced that there's only one winner. That is the legal education in Thailand is now on par with Singapore, Malaysia, and the rest of the world. You have worked so hard, voluntarily. So many of you, some come from far away, from the southernmost of Thailand, and I don't like to say as to compete with each other rather than spend time with your colleagues, with your friends, with lawyers of your generation, which will, I'm sure, bring the Thai legal profession generally to the new heights in your time. And go back to your law schools and encourage the law school to teach future lawyers in Thailand in order able to do extensive research like yourselves. There's no hindrance on the physical access to law text anymore when you can access anywhere on the digital platform. So do work hard, and don't mind that it is a language not in of the one that is closest to you. So it just widen your horizon. Research, if you just stick the research to your own language, then your world is so small. Widen your horizon. You look at authorities from everywhere in the world. And now everybody can have access to all the greatest decisions of the world, including Thai. So we will be well represented in the ASEAN Law Association Moot competition. You do great among the lawyers, law students from National University of Singapore, Singapore Management University, University of Philippines, Indonesia, or even Hanoi, Vientiane, or why not Phnom Penh. So go out in the world and fly the flag of your country, and I'm sure you make us proud, prouder than my generation have done. Thank you very much, and bring these great things back to your law school. Tell your law professors we must do something in order to be top of the world. Thank you.
I would like to thank our esteemed judges for their invaluable insights and expertise, and also thank you participants for your dedication. You worked so hard to come to today. Soon we will know which team will be the winner of the ASEAN Law Association of Thailand Moot Competition 2026 and will be representing Thailand in the ASEAN round. So now we will take a break for 15 minutes to arrange our award ceremony, and we will be back with the winner announcement. Thank you.มีน้องคนไหนป้ายทะเบียนรถคอละข้างหอยหีบ7333นะคะอ๋อ เขาให้ไปปลดเบรกมือให้หน่อยค่ะพี่เปิ้ล
สวัสดีครับ ขออนุญาตประชาสัมพันธ์อีกครั้งนะครับในเรื่องของการขึ้นรับรางวัล เมื่อพี่ประกาศชื่อทีมให้น้องๆขึ้นไปที่บนเวทีโดย1รางวัลจะมีถ้วยหรือโล่รางวัลแล้วก็ประกาศนียบัตรและก็เงินรางวัลนะครับโดยเมื่อน้องคนที่รับถ้วยหรือโล่รางวัลเรียบร้อยแล้วมีการถ่ายรูปเสร็จเรียบร้อยแล้วให้ส่งถ้วยหรือโล่รางวัลต่อให้กับเพื่อนคนถัดไปนะครับเพื่อที่จะรับรางวัลไปประกาศนียบัตรและก็เงินรางวัลต่อไปครับขอบคุณครับ สวัสดีครับ ขอต้อนรับน้องๆผู้เข้าร่วมการแข่งขันว่าความในศาลจำลองเพื่อคัดเลือกตัวแทนประเทศไทยเข้าร่วมการแข่งขันระดับนานาชาติของสมาคมกฎหมายอาเซียน ประจำปีพุทธศักราช 2569 ASEAN Law Association Moot Competition 2026 และผู้เข้ารับชมผ่านทาง Facebook Live และ YouTube ทุกท่านเข้าสู่ช่วงพิธีมอบถ้วยรางวัลประกาศนียบัตรและเงินรางวัลนะครับกับผมนายวรวัฒน์มนตรีกุลณอยุธยานิติกรสำนักอนุญาโตตุลาการสำนักงานศาลยุติธรรมรับหน้าที่เป็นพิธีกรในช่วงพิธีการนี้ครับเรียนท่านเลขาธิการขออภัยครับเรียนท่านธีรไทยเจริญวงศ์เลขาธิการสำนักงานศาลยุติธรรมท่านผู้พิพากษาท่านผู้บริหารสถาบันอนุญาโตตุลาการสำนักงานศาลยุติธรรมและท่านคณะกรรมการทุกท่านตามที่สำนักงานศาลยุติธรรมจัดการแข่งขันว่าความในศาลจำลองเพื่อคัดเลือกตัวแทนประเทศไทยเข้าร่วมการแข่งขันระดับนานาชาติของสมาคมกฎหมายอาเซียนประจำปีพุทธศักราช 2569 ASEAN Law Association Moot Competition 2026 รอบคัดเลือกในวันที่ 17 มีนาคม 2569 รอบรองชนะเลิศและรอบชิงชนะเลิศในวันที่ 18 มีนาคม 2569 โดยมีวัตถุประสงค์เพื่อเป็นการส่งเสริมให้เยาวชนคนรุ่นใหม่เล็งเห็นถึงความสำคัญของกฎหมายประเด็นทางกฎหมายที่เกิดขึ้นทั้งภายในประเทศและในภูมิภาคอาเซียนอีกทั้งเป็นการเปิดโอกาสให้นิสิตนักศึกษาในสาขานิติศาสตร์นำองค์ความรู้ทางกฎหมายมาประยุกต์ใช้ในการแข่งขันรวมตลอดถึงการฝึกฝนการใช้ภาษากฎหมายที่ถูกต้องและโดยเฉพาะอย่างยิ่งเพื่อคัดเลือกตัวแทนของประเทศไทยไปแข่งขันระดับนานาชาติของสมาคมกฎหมายอาเซียนประจำปีพุทธศักราช 2569 ซึ่งทีมที่ชนะการแข่งขันในแต่ละรอบจะได้รับรางวัลดังนี้ทีมที่ชนะการแข่งขันรอบการแถลงการปิดคดีด้วยวาจาในศาลจำลองรอบชิงชนะเลิศจะได้รับถ้วยรางวัลประธานศาลฎีกาใบประกาศนียบัตรชนะเลิศการแข่งขันว่าความในศาลจำลองของคณะกรรมการแห่งชาติสมาคมกฎหมายอาเซียนประจำประเทศไทยประจำปีพุทธศักราช 2569 และเงินรางวัลจำนวน 70,000 บาทและเป็นตัวแทนประเทศไทยเข้าร่วมการแข่งขันว่าความในศาลจำลองอาเซียนประจำปีพุทธศักราช 2569 ณ กรุงเทพมหานครประเทศไทยทีมที่ได้รับรางวัลรองชนะเลิศอันดับหนึ่งจะได้รับรางวัลเลขาธิการสำนักงานศาลยุติธรรมใบประกาศนียบัตรรองชนะเลิศอันดับหนึ่งการแข่งขันว่าความในศาลจำลองของคณะกรรมการแห่งชาติสมาคมกฎหมายอาเซียนประจำประเทศไทยประจำปีพุทธศักราช 2569 และเงินรางวัลจำนวน 50,000 บาททีมรองชนะเลิศอันดับ2จำนวน 2 ทีมจะได้รับรางวัลสมาคมกฎหมายอาเซียนประจำประเทศไทยใบประกาศนียบัตรรองชนะเลิศอันดับ2และเงินรางวัลจำนวน 30,000 บาททีมที่ได้รับคะแนนคำแถลงการปิดคดีเป็นลายลักษณ์อักษรจากคณะกรรมการสูงสุดจะได้รับโล่รางวัลคำแถลงการปิดคดีเป็นลายลักษณ์อักษรยอดเยี่ยม Best Memorial Trophy ใบประกาศนียบัตรคำแถลงการปิดคดีเป็นลายลักษณ์อักษรยอดเยี่ยมและเงินรางวัล 8,000 บาทผู้สมัครเข้าร่วมการแข่งขันที่ได้รับคะแนนประเมินรายบุคคลจากคณะกรรมการสูงสุดในรอบคัดเลือกจะได้รับโล่รางวัลผู้แถลงการด้วยวาจาดีเด่น Best Mooter Trophy ใบประกาศนียบัตรผู้แถลงการด้วยวาจาดีเด่นและเงินรางวัล 5,000 บาทนอกจากนี้ผู้สมัครเข้าร่วมการแข่งขันทุกคนจะได้รับประกาศนียบัตรการเข้าร่วมการแข่งขันว่าความในศาลจำลองเพื่อคัดเลือกตัวแทนประเทศไทยเข้าร่วมการแข่งขันระดับนานาชาติของสมาคมกฎหมายอาเซียนประจำปีพุทธศักราช 2569 ASEAN Law Association Moot Competition คนละ1ฉบับบัดนี้ได้เวลาอันสมควรแล้วขอเรียนเชิญท่านธีรไทยเจริญวงศ์เลขาธิการสำนักงานศาลยุติธรรมขึ้นบนเวทีเป็นประธานกล่าวแสดงความยินดีแก่ผู้เข้าร่วมการแข่งขันและขอเรียนเชิญท่านสรวิทย์ลิมปรังสีรองอธิบดีผู้พิพากษาศาลทรัพย์สินทางปัญญาและการค้าระหว่างประเทศกลางขึ้นกล่าวรายงานต่อท่านประธานขอเรียนเชิญครับ
เรียนท่านเลขาธิการสำนักงานศาลยุติธรรมกระผมในฐานะประธานกรรมการคัดเลือกตัวแทนนิสิตนักศึกษาเข้าร่วมการแข่งขันว่าความในศาลจำลองของสมาคมกฎหมายอาเซียนประจำปีพุทธศักราช 2569 ขอรายงานการจัดโครงการแข่งขันว่าความในศาลจำลองเพื่อคัดเลือกตัวแทนประเทศไทยเข้าร่วมการแข่งขันระดับนานาชาติของสมาคมกฎหมายอาเซียนประจำปี 2569 ASEAN Law Association Moot Competition 2026 ซึ่งจัดขึ้นระหว่างวันที่ 17 ถึง 18 มีนาคม 2569 สืบเนื่องจากสมาคมกฎหมายอาเซียนประจำประเทศไทยจะเป็นเจ้าภาพ จัดการประชุมใหญ่สมาคมกฎหมายอาเซียนครั้งที่ 15 และการประชุมคณะกรรมการบริหารของสมาคมกฎหมายอาเซียนครั้งที่ 47 ประจำปี พ.ศ. 2569 ระหว่างวันที่ 19 ถึง 24 กรกฎาคม 2569 ณ กรุงเทพมหานคร ประเทศไทย โดยมีการแข่งขันว่าความในศาลจำลองของสมาคมกฎหมายอาเซียนครั้งที่ 2 เป็นกิจกรรมหนึ่งภายใต้การประชุมดังกล่าว โดยมีวัตถุประสงค์เพื่อเผยแพร่และทำให้เกิดการตระหนักถึงกฎหมายการลงทุนระหว่างประเทศภายใต้กรอบอาเซียนรวมทั้งส่งเสริมและสนับสนุนให้เยาวชนนักศึกษานิสิตกฎหมายเพิ่มพูนทักษะในวิชาชีพกฎหมายอันเป็นการพัฒนาวิชาชีพกฎหมายในประเทศไทยอีกทางหนึ่งและเพื่อการดำเนินการจัดการแข่งขันดังกล่าวเป็นไปด้วยความเรียบร้อยและบรรลุตามวัตถุประสงค์คณะกรรมการแห่งชาติสมาคมกฎหมายอาเซียนประจำประเทศไทยโดยมีเลขาธิการสำนักงานสารยุติธรรมทำหน้าที่เลขาธิการกรรมการแห่งชาติจึงกำหนดให้มีการจัดโครงการแข่งขันว่าความในศาลจำลองเพื่อคัดเลือกตัวแทนประเทศไทยเข้าร่วมการแข่งขันระดับนานาชาติดังกล่าวการจัดโครงการครั้งนี้เปิดรับสมัครระหว่างวันที่ 24 ธันวาคม 2568 ถึงวันที่ 31 มกราคม 2569 โดยได้รับความสนใจจากนิสิตนักศึกษาจากสถาบันการศึกษาต่างๆมีผู้สมัครเข้าร่วมการแข่งขันทั้งหมด 18 ทีมจาก 6 มหาวิทยาลัยได้แก่จุฬาลงกรณ์มหาวิทยาลัยมหาวิทยาลัยธรรมศาสตร์มหาวิทยาลัยกรุงเทพมหาวิทยาลัยรามคำแหงมหาวิทยาลัยขอนแก่นและมหาวิทยาลัยสงขลานครินทร์ผู้สมัครเข้าร่วมการแข่งขันจะต้องจัดทำคำแถลงการภาษาอังกฤษหรือ Memorials ฝ่าย Claimant จำนวน 1 ฉบับและฝ่าย Respondent 1 ฉบับซึ่งคณะกรรมการได้คัดเลือกโดยให้คะแนนจากคำแถลงการภาษาอังกฤษทั้ง 2 ฉบับทีมที่ได้คะแนนสูงสุด8 อันดับแรกจะได้เข้าแข่งขันการแถลงการปิดคดีด้วยวาจา Oral Round รอบคัดเลือกจำนวน 8 ทีมที่รับคะแนนมากที่สุด 4 อันดับแรกจะเข้าสู่รอบรองชนะเลิศจากนั้นทีมที่ได้คะแนนสูงที่สุด 2 อันดับแรกจะเข้าสู่รอบชิงชนะเลิศทั้งนี้ทีมที่ชนะการแข่งขันรอบชิงชนะเลิศจะรับถ้วยรางวัลประธานศาลฎีกาพร้อมเป็นตัวแทนประเทศไทยเพื่อเข้าร่วมการแข่งขันว่าความในศาลจำลองอาเซียนประจำปี พ.ศ. 2569 ต่อไปซึ่งการแข่งขันได้ดำเนินมาจนเสร็จสิ้นด้วยความเรียบร้อยและได้ผู้ชนะเลิศซึ่งจะเป็นตัวแทนของประเทศไทยแล้วบัดนี้ได้เวลาสมควรแล้วกระผมขอเรียนเชิญท่านเลขาธิการสำนักงานสารยุติธรรมได้กรุณาให้เกียรติกล่าวแสดงความยินดีให้แก่ผู้เข้าร่วมการแข่งขันทุกท่านขอกราบเรียนเชิญครับ
ท่านผู้พิพากษาท่านคณะกรรมการและผู้เข้าร่วมการแข่งขันทุกท่านครับผมเองก็รู้สึกยินดีนะครับแล้วก็ดีใจเป็นอย่างยิ่งเลยที่วันนี้ได้เห็นถึงขีดความสามารถแล้วก็เห็นถึงศักยภาพของผู้เข้าร่วมการแข่งขันซึ่งเป็นตัวแทนจากมหาวิทยาลัยชั้นนำหลายมหาวิทยาลัยที่เราได้พัฒนาขีดความสามารถขึ้นอีกระดับหนึ่งการแข่งขันที่สำนักงานสารยุติธรรมจัดขึ้นในครั้งนี้คงเป็นข้อบ่งชี้ถึงศักยภาพเบื้องต้นของพวกเรานะครับที่จะทำให้เห็นได้ว่ามีศักยภาพอยู่ในเกณฑ์มาตรฐานแล้วก็สามารถต่อยอดไปในเวทีอาเซียนอาจจะต่อยอดไปถึงเวทีระดับโลกได้อีกด้วยนะครับต้องขอบคุณสถาบันการศึกษามหาวิทยาลัยชั้นนำหลายๆแห่งนะครับที่สนับสนุนให้พวกเราทุกๆคนได้มีโอกาสแสดงศักยภาพของตัวเองออกมาในเวทีที่เหมาะสมนะครับแล้วก็จะถือว่าพวกเราซึ่งเป็นผู้ชนะเนี่ยจะถือเป็นตัวแทนของประเทศไทยในการเข้าแข่งขันในเวทีระดับอาเซียนต่อไปนะครับผมขอบคุณคณะกรรมการจัดการแข่งขันนะครับขอบคุณทีมงานทุกๆคนและที่สำคัญที่สุดต้องขอบคุณผู้เข้าแข่งขันทุกๆคนที่ทุ่มเทแล้วก็มุ่งมั่นนะครับที่จะแสดงศักยภาพของตัวเองออกมาให้คณะกรรมการเห็นได้อย่างชัดเจนเพื่อเฟ้นหาผู้ชนะเป็นตัวแทนของประเทศไทยไปสู่เวทีระดับอาเซียนได้อย่างมีความภาคภูมิใจนะครับการจัดการแข่งขันการว่าความในศาลจำลองเพื่อคัดเลือกตัวแทนประเทศไทยในครั้งนี้นะครับก็ต้องถือว่าเป็นเรื่องที่ให้โอกาสกับนิสิตนักศึกษาในสาขาวิชานิติศาสตร์ที่จะนำองค์ความรู้ต่างๆที่ได้เล่าเรียนได้ศึกษามาเนี่ยมาประยุกต์ใช้กับการแข่งขันเราคงจะพัฒนาตัวเองต่อไปคงไม่หยุดนิ่งอยู่เพียงเท่านี้นะครับและที่สำคัญที่สุดสิ่งต่างๆประสบการณ์ต่างๆที่ได้รับจากการแข่งขันในครั้งนี้ผมเชื่อมั่นว่าพวกเราทุกๆคน จะนำไปเป็นพื้นฐานในการประกอบวิชาชีพที่สำคัญได้ในอนาคตอย่างแน่นอนนะครับสุดท้ายนี้ครับผมขอแสดงความชื่นชมกับคณะกรรมการจัดการแข่งขันนะครับกับผู้จัดการแข่งขันที่จัดการแข่งขันในครั้งนี้ได้อย่างเรียบร้อยราบรื่นสำเร็จไปตามวัตถุประสงค์ที่ตั้งไว้นะครับแล้วก็ขอบคุณทุกๆฝ่ายที่ให้ความร่วมมือที่จะช่วยกันพัฒนาศักยภาพของบุคลากรของเราตั้งแต่ในระดับชั้นปริญญาตรีนะครับเพื่อที่จะได้นำความรู้ต่างๆเนี่ยไปต่อยอดพัฒนาตัวเองให้ดียิ่งขึ้นในโอกาสต่อๆไปนะครับก็ต้องขอบคุณในโอกาสนี้ด้วยแล้วก็ต้องขอแสดงความยินดีกับตัวแทนที่ชนะเลิศนะครับแล้วก็ได้เป็นตัวแทนของประเทศไทยก้าวเข้าสู่เวทีระดับอาเซียนต่อไปขอบคุณครับ
ขออนุญาตท่านเลขาอยู่ที่ด้านบนเวทีก่อนนะครับลำดับต่อไปขอเรียนเชิญท่านธีรไทยเจริญวงศ์เลขาธิการสำนักงานศาลยุติธรรมมอบถ้วยรางวัลใบประกาศนียบัตรพร้อมเงินรางวัลสำหรับการแข่งขันว่าความในศาลจำลองเพื่อคัดเลือกตัวแทนประเทศไทยเข้าร่วมการแข่งขันระดับนานาชาติของสมาคมกฎหมายอาเซียนประจำปีพุทธศักราช 2569 ASEAN Law Association Moot Competition 2026 ครับสำหรับรางวัลแรกที่จะประกาศในวันนี้ได้แก่รางวัลผู้แถลงด้วยวาจาดีเด่นหรือ Best Mooter Trophy ซึ่งเป็นรางวัลสำหรับผู้สมัครเข้าร่วมการแข่งขันที่ได้รับคะแนนประเมินการแถลงการด้วยวาจารายบุคคลจากคณะกรรมการสูงที่สุดในรอบคัดเลือกผู้เข้าแข่งขันที่ได้รับรางวัลนี้ได้แก่มิสนัชชาสุริยะพานิชครับขอเชิญขึ้นรับรางวัลครับเหลือเงินรางวัลครับลำดับถัดไปรางวัลคำแถลงการปิดคดีเป็นลายลักษณ์อักษรยอดเยี่ยมหรือ Best Memorial Trophy ซึ่งเป็นการรวมผลคะแนนจากการทำคำแถลงการปิดคดีเป็นลายลักษณ์อักษรในฐานะผู้เรียกร้องและผู้คัดค้านโดยทีมที่ได้รับคะแนนบันทึกคำแถลงการปิดคดีเป็นลายลักษณ์อักษรจากคณะกรรมการสูงสุดทีมที่ชนะรางวัลนี้ได้แก่ทีม G Sigma Sodium ครับขอเชิญขึ้นรับรางวัลครับลำดับต่อไปจะเป็นการประกาศผลการแข่งขันรอบการแถลงการปิดคดีด้วยวาจาในศาลจำลองโดยเราจะเริ่มจากรางวัลรองชนะเลิศอันดับ2ก่อนนะครับรางวัลรองชนะเลิศอันดับ2สำหรับรางวัลนี้จะมีอยู่ด้วยกัน2รางวัลโดยทีมที่ได้รับรางวัลนี้จะได้รับถ้วยรางวัลสมาคมกฎหมายอาเซียนประจำประเทศไทยไปประกาศนียบัตรรองชนะเลิศอันดับ2และเงินรางวัลจำนวน 30,000 บาทโดยทีมที่ชนะรางวัลนี้ทีมแรกได้แก่ ทีม D PPPN ครับขอเชิญขึ้นรับรางวัลครับและทีมที่2ที่ได้รับรางวัลนี้ได้แก่ทีม H Peace ครับขอเชิญขึ้นรับรางวัลครับสำหรับรางวัลรองชนะเลิศอันดับ1ทีมที่ได้รับรางวัลนี้จะได้รับถ้วยรางวัลเลขาธิการสำนักงานศาลยุติธรรมใบประกาศนียบัตรรองชนะเลิศอันดับ1และเงินรางวัลจำนวน 50,000 บาททีมที่ชนะรางวัลนี้ได้แก่ทีม E Due Process Girl ครับขอเชิญขึ้นรับรางวัลครับ และสุดท้ายนะครับรางวัลชนะเลิศจะได้รับถ้วยรางวัลประธานศาลฎีกาใบประกาศนียบัตรชนะเลิศการแข่งขันว่าความในศาลจำลองของคณะกรรมการแห่งชาติสมาคมกฎหมายอาเซียนประจำประเทศไทยประจำปีพุทธศักราช 2569 และเงินรางวัลจำนวน 70,000 บาทและเป็นตัวแทนประเทศไทยเพื่อเข้าร่วมการแข่งขันว่าความในศาลจำลองอาเซียนประจำปีพุทธศักราช 2569 ณ กรุงเทพมหานครประเทศไทยโดยทีมที่ได้รับรางวัลชนะเลิศได้แก่ทีม A Celestial Fighter ครับขอเชิญขึ้นรับรางวัลครับขออนุญาตท่านเลขาอยู่ที่ด้านบนเวทีก่อนนะครับลำดับต่อไปจะเป็นการถ่ายภาพหมู่ร่วมกันขอเรียนเชิญท่านผู้พิพากษาท่านผู้บริหารสถาบันวิทยาโตตุลาการสำนักงานศาลยุติธรรมและท่านคณะกรรมการทุกท่านขึ้นถ่ายภาพร่วมกันที่ด้านบนเวทีครับขอเชิญน้องๆทุกคนที่ด้านหน้าเวทีด้วยนะครับน้องๆขอเชิญที่ด้านหน้าเวทีนะครับแบ่งเป็น2แถวก็ได้นะครับเอาถ้วยรางวัลมาด้วยก็ได้ครับถ้วยรางวัลน้องแบ่งเป็น2แถวได้นะครับน้องขยับถอยหลังลงไปนิดนึงครับ ขอขอบพระคุณท่านธีรไทยเจริญวงศ์เลขาธิการสำนักงานศาลยุติธรรมและขอขอบพระคุณท่านผู้พิพากษาท่านผู้บริหารสถาบันอริยโตตุลาการสำนักงานศาลยุติธรรมและท่านคณะกรรมการทุกท่านเป็นอย่างสูงที่กรุณาให้เกียรติมาร่วมงานในวันนี้ครับในนามของสถาบันอริยโตตุลาการ TAI ขอขอบคุณผู้เข้าร่วมการแข่งขันทุกท่านที่ให้ความสนใจเข้าแข่งขันว่าความในศาลจำลองเพื่อคัดเลือกตัวแทนประเทศไทยเข้าร่วมการแข่งขันระดับนานาชาติของสมาคมกฎหมายอาเซียนประจำปีพุทธศักราช 2569 ขอบคุณครับ